But they did this study, these two professors, on how we in custody courts are teaching parents to be poor parents because we're competing. Who's going to get them the bigger Christmas present? Who's going to get them?
Hi, I'm Emily McFarling. I am a family law attorney in Las Vegas, and I am here with Judge Margaret Pickard. She is the family court judge for Department V. She was a family law attorney and parenting coordinator specializing in high conflict custody cases. Since 2015, she was a hearing master and now a judge. She oversees child welfare cases and associated child custody cases. Welcome.
Thank you so much for having me. I appreciate being here.
And I also have with me Nicolas Ponzo. He is a psychotherapist. He has been practicing working with families and children for over 30 years. He provides therapy, consulting services, and specifically provides services for the family court in Clark County as well. And that's what we're going to be discussing today, our outsourced providers in child custody cases. So welcome.
Thank you very much.
So to start off, let's just give a little background, I guess, on what we're going to be talking about today. So in the family court, there are child custody cases where the court's tasked with making child custody decisions. And there are situations where a psychotherapist or other type of professional might be brought in to be involved in the case. What are some situations where we would have an outsourced provider in a child custody case?
There are a few. I think it's a fairly broad range. So obviously everything that is outsourced pertains to children. So the kinds of things that are outsourced, and not necessarily in terms of prevalence, but you would imagine that custody evaluations are one of the things that are outsourced. I don't think that that's the most common type of referral. However, it is needed. Child interviews, interestingly enough, are often required by family court judges. They are referred to often as forensic child interviews because it is before the court and there's information about children's functioning in the context of custody disputes or when motions are brought forth about issues, whether it's abuse or not necessarily the kinds of things that the CPS would look at, but sometimes judges want perspective from the children to describe their experiences within home environments, their experience with parents, parenting styles, things that might be affecting the children's development or their functioning. So child interviews, and then reunification therapy, which involves an assessment process as well as a therapeutic process. And oftentimes in reunification matters, the issue is that one of the parents doesn't have contact, is estranged from the children, and they are presenting in court with a request to resume their relationship, restore their relationship. There are a lot of reasons why the reunification is requested, and I could explain that further at some point, but reunification sometimes involves, let's say, allegations of about a parent being inappropriate or abusive, and again affecting the child's overall functioning, or an allegation of alienation in which one parent is claiming that they are alienated from the children due to the functioning of the other parent influencing the children. Judges want to know if there is an alienation component in the estrangement, why the children are separated. But sometimes parents who present to the court who don't claim that they're being alienated may say they've had difficulties, issues in their maintaining their parent functions. Either they were out of the picture, not available, may have had, I see a broad range of presentations, may have had a substance abuse problem, may have had difficulties with their health status. They may have relocated and then come back. But essentially, they're looking for a way to re-engage and restore their parenting functioning and the relationship. And then the kinds of things that also require outsourced evaluations are things like parent coordination, which is essentially parents who are in dispute. In many areas that involve outsourced evaluators, there is an underlying feature or a set of factors that suggests that parents are in conflict. So a lot of times people like us would refer to parents as high conflict co-parents. So when there's a high conflict co-parenting situation, judges may not wish to, and I'm sure you can comment on this, but they may not wish to see everything presented to the court, every dispute, every conflict, every parenting decision that needs to be made. So they'll outsource it to a parenting coordinator, and my understanding has always been that the parent coordinator functions for the court in a quasi-judicial sort of manner where they have some authority to make determinations. They're going to try to mediate solutions or try and create consensus over what the dispute is, but everything has to be directed towards the best interest of a child. So a parent coordinator can engage in a lot of things, including investigations and collateral interviews, gathering information. It's directed at formulating or assessing what the child needs and then helping parents have an understanding and resolve the dispute and the conflict.
I think Judge Harder, the late Judge Harder, would talk about it as a high-priced babysitter, helping parents make daily decisions that are not major decisions like custody that the court needs to make. Of course, we're not delegating that authority. But I do think that there are times where you have parents, as you well know, who simply cannot agree on even the slightest issue, whether it's a haircut or whether or not Johnny can go to grandma's funeral and so mom's willing to trade a day. There's a lot of those basic day-to-day babysitting factors or issues that the parent coordinator can become involved with. And I think that they're incredibly helpful. Otherwise, the system is bogged down by, and the time it takes to get in front of a judge, right? Whereas a parent coordinator can address it that day or the next day, whereas a judge might be 6 months down the road with a motion practice.
That's my experience. There's a presentation of a dispute, a conflict, and they need some resolution guidance. They would have to wait weeks, if not months, to get a hearing, because that's the only way that they're going to have a judge preside over this, whereas the parent coordinator may have an appointment later in the week or, within a week or so.
Right, and they're very much tiebreakers over minor day-to-day disputes. And so I think it's important that to understand all of these things are the step one. How do we get these parents resolved, resources, and how can we help the court make decisions? In my opinion, I think it's really effective and helpful.
So talking more about parenting coordinators, can a parenting coordinator be appointed against the objection of one of the parties?
Well, my experiences with a recent case law, really you need to have consensus on this for the most part, that the parents need to have somebody who's appointed. Maybe it's the judge gives them 3 different names and they each pick 2 of those and they try to come to some consensus. I think historically, yeah, the answer is yes, but I think with the new recent, really since the Harrison case, I think the department's the courts are very hesitant about, Bautista and Harrison, right? I think that was what started it. But I think that they're really hesitant about stepping in and making those decisions and saying we're going to delegate this. Because if the parents don't buy in, it becomes almost an impossible situation. So, and of course, when I was as a parent coordinator, Harrison came down in part because that was my case. And they basically said you can't delegate. And then with the more recent cases that you are going to have to get some consensus to some degree. So that's how I view it. I mean, obviously, you're
I
on
see
that
it the same
practice
way.
side,
I think that if a judge were to appoint a parenting coordinator against the objection of one of the parties and they were to appeal it, it would probably get overturned.
Right.
That's my expectation, although it hasn't explicitly been appealed and told to us on it. But we did. The Batista Bacone case did spell out the limits of the authority of a parenting coordinator, that they cannot actually change custody on a permanent basis.
Yes.
Emergencies and smaller issues, but no major custody changes.
Can be delegated to third party, absolutely. So I think those are important. But those 2, I think what Nick does so much is help the court gather the necessary information for a court to make decisions themselves, right? So you do a lot of these background child interviews. I mean, I do a lot of my own child interviews because that's my background, but a lot of judges are not touching that with a 10-foot pole. Why would you say that people would come to you for a child interview as opposed to going to, say, the Family Mediation Center? What do you see as the difference in why you get those referrals?
The difference is sometimes it's a subtle difference, but really it's a matter of the scope of the interview process. So, well, firstly, they're referred. So often they are court orders, and it is generated by the judge's need for extensive information about child functioning. And they're incorporating the child in the process, meaning that the child has a voice. And that voice is presented usually through a report or possibly testimony in some cases from the examiner or the clinician. What's the difference between an outsourced evaluator or an outsourced a person that does child interviews versus the Family Mediation Center? Well, the Family Mediation Center has a template from what I understand. I've read many of their reports. They will follow a certain template. They can expand on it a little bit based upon their feel for or understanding about the background and various things that are presented, but it is limited. It's usually a one-time interview. So many
And a short interview.
An hour to an hour and a half is what I understand. Now, many judges know that, and in certain cases, that's all they want. But in many cases, in my experience, they want more. So there's a much more extensive sort of evaluation and investigation, if you will. It goes into broader areas rather than just a list of things like how is the child functioning socially, academically, what's their home life like, what would they say about their parents, how would they rate their parents, and so on. So you can look at this as like a form almost that's being filled out by the child, except it's, an interview. And the person that's doing child interviews for the court, outside of the Family Mediation Center, is able to look at the background of the case. They could incorporate the parents too to get some perspectives on the history of the situation, and then sort of tailor make the assessment. They could target certain areas that wouldn't be included in that format or template, specific to each case, as opposed to a generic process.
And I think those are really helpful if you have a forensic child interview as opposed to really just a one-time interview where one parent brings that child in, which obviously gives them some preference. I think when you have that, say dad brings a kid in or mom brings a kid in, but I think a forensic child interviewer is going to be able to discern the difference, maybe have mom bring the child in one time, dad bring the child in one time, and get that overall picture that a one-time shot interview isn't going to give you.
Absolutely, that's correct. There's a more balanced approach. Each parent can bring them in. The evaluator can note differences in the child's presentations based on who's bringing the child in. I mean, that is not the bulk or the core of the interview process, but those kinds of things are sometimes necessary and notable observations. And they're going to obviously meet over time. And my protocol is that I'll do multiple interviews, and part of what you're investigating is consistency. Are there changes? Does the narrative presented by the child change, and for what reason? So you would see that over time as opposed to contained in one interview.
Right.
In Clark County, the parties who appear in family court are not allowed to get a child interviewed for court purposes without a court order. Do you find then that any child interview that you have is generally court ordered, or do you have other situations where you have people coming to you for forensic child interviews?
I don't recall any forensic child interviews that weren't court ordered. I think that's the short answer to that. I don't think people are, in my experience, compelled to bring their children for child interviews. They have a motive. I mean, the parents that have some motivation to have the child assessed, let's say, just interviewed to obtain the child's perspectives. They may have a goal in mind, so they'll present that to the court. So they're in agreement, if you think about it, with the process to proceed. There are a lot of objections, I find, about what should occur. There are some people that contest the very idea of having their children interviewed. But I find that by the time it gets to someone like me, it's been ordered, and therefore it's been agreed upon, and people understand the purpose and the scope of it.
And I think we're one of the few countries that don't regularly interview kids. And I think if you look at other communities, other places, they do, whether you're in Australia or in Canada, there's more of child interaction. And sometimes a kiddo just wants to be heard. So I do child interviews, even though I may already know the outcome in a child welfare case, but that child wants to come in and talk to me. And I did one today, and I said at the end, what questions do you have for me? And they're like, well, how many kids do you have? Do you have kids? And what they ask me questions. And do you play soccer? That helps them feel like somebody's listening to me, and I can also be part of that process. Now, of course, I've already asked them what their favorite things are to do, what they think about each household, give me your daily routine. And then it kind of brings them in. And kids need a voice. And I think we so often disregard that, especially in this country. We think, oh, we're just going to listen to the parents. And I will say this, as I'm sure Nick will talk about, kids lie. And sometimes kids will tell mom one thing and they'll tell dad the exact opposite. And now the parents are litigating because they authentically believe that child maybe doesn't want to see dad or doesn't want to see mom. But when you interview them, the kids are often like, oh, well, I like my dad. And when I practiced in Montana first, and when I did in Montana, I did child custody exchanges. And I was amazed at the number, it was early in my career, the number of times, say you have mom who's like, the kids hate dad. And then I would be at the custody exchange and the kids would be like, Daddy, we're so excited to see you, as soon as mom leaves. But when mom's there, they present as fearful and they're kind of meeting the expectations. And so kids will tell each parent what they think they want to hear, which often leads to litigation. And I think that's why child interviews are incredibly important on a forensic level that does it right with, both parents engaged and involved. And it's just so interesting too, because parents come in and qualitatively, they think we as a judge are going to say, oh gosh, your parent's better. That's not what we're talking about in family court. We are talking about basic parental skills and very basic parenting abilities. And if it's too low, then Child Protective Services gets involved. Otherwise, we're talking about, we do have a preference that both parents are going to be involved in that child's life. And parents don't realize that. And I think the job of an attorney is to manage expectations and tell the client. Like, you can't just come in and say you think you're better because you're going to get the kiddo to school on time and you're going to do the homework better than the other parent. Parents have a constitutional right to parent their children. And I think I explain that to parents from day one when they come in. Like, here's the law. Here's what you're asking me to do. Here's what the preferences, presumptions, and I go through it with them. And educating parents in court is incredibly helpful, I find. Yeah, so.
In a sense, you've described a consideration on the part of some parents who are obviously disputing custody, that the quality of their parenting supersedes the quality of the other,
right.
And they should be considered as the de facto caregiver. And it's often a contest, right, that's being presented. And in that contest, somebody wants to win. And of course, there's a motivation to demonstrate superiority. But as a judge, you would know that's not the standard.
Right.
Of who is the better parent. I mean, people can make claims. I hear it. I hear many presentations, who's better at helping with homework, who's a better cook, who keeps a better home, and so on. And I think what you suggested is the bar is not that high.
It's very low. It's very low, people.
You have the right to parent, even if you don't provide some, certain superior standard, and so on. The other thing that I think is important that you've mentioned is it is important to give the children a voice, and so it's often the case that judges are considering the importance of that, not just recommending it but ordering it and bringing them into the process and then I think it requires the skill of someone like yourself or a skilled clinician to develop a good rapport with that child and help them feel comfortable, and then be able to note how the child functions within the dynamic of being pulled in different directions, wanting to please. I think that's a very prevalent dynamic. They want to please each parent. I have kids telling me, "Are you going to tell my parents what I have to say?" Have you heard that too?
Oh, all the time, all the time.
Yeah.
And I tell them, your parents have a right to hear it. In the courtroom, for me, when I interview a child, I have a very specific practice that there's a huge television screen, right, where everybody's logged in. I don't actually. I prefer it if a third party brings the kiddos in, like grandma, grandpa, as opposed to mom or dad, and then they sit in there. And they talk to me if they have a CASA, or in my cases, I have a lot of court-appointed counsel for the kids, a CAP attorney. And so we talk to them and they face away from the screen. But everybody's watching, but they don't have their camera on, their audio or their video, they're all muted. So they procedurally have the right to hear what their kiddo has to say. And it's kind of interesting. If they're represented, I often just talk to the child and the attorneys will note it. And then I break halfway through and I just talk to the attorneys and I say, are there any follow-up questions you think we should ask, that I should ask, go through? I don't allow cross-examination. Obviously, there's testimony by alternative methods and we acknowledge that. But those kiddos need to hear what's happening. And today, I made the decision and I stated it to the attorneys and I said, do the kids want to come in and hear and ask me why I decided this? And they did. They said, why did you do this? And I said, that's a good question because the law requires that I, do certain things. And I always prioritize the rights of the parents. They wanted to go to a third party. And I said, your parents have a right. And that was an interesting conversation, right? So.
Our law allows for a child who's 14 or older to actually testify in court, and then under 14, they can you have to file a motion to have them testify by alternative means or other. Do you find that you have children actually coming in and testifying in court, or is that something you dissuade?
Well, for me, for the courtroom setting, if they're age eligible, I always grant a request for testimony by alternative methods, and that's why I tend to interview a lot of the kiddos. If they're older, I ask the question, do they want to testify, right? And so, because a lot of kids don't actually want to testify when they're having to face their parents, and if they do testify, then that's when I dismiss the parents, and the parents can watch, but the attorneys are there, and the attorneys are able to propose questions first to the court, and then we take a break, and then I ask if they have follow-up questions so the parents can be observing. But I worry, if you have a child, and you can give me your 2 cents on this, if you have a 17-year-old who says, I want to testify, I want to tell you how awful my parent is, I think there's alienation, and I worry about that. It's not really common, I think, that for me, that the kids are going to come in and say, I hate one of my parents, and this is why, in the absence of alienation or some kind of influence by the other parent, they say little things like, it's your dad on the phone again, or whatever, to kind of get that kiddo to believe that maybe there's something to worry about with one parent. So I worry if I have an older child who's adamant about taking the stand, and it's very one-sided in their testimony, because usually they'll be a little bit neutral and they'll hem and haw about what they've said to one parent. So that's my experience. I don't know if you have a different kind of take on that.
I don't have a different take on it. It's also my experience. I think it occurs in the context of what I often refer to as polarized feelings. And so one of the things that I evaluate, I have to evaluate how children are describing their experiences with each parent, and sometimes they do have a preference. And that is not to say that they don't have a basis or a rationale for a preference. And that's part of an assessment of sorts, whether you're doing an alienation study or certainly a child custody evaluation or reunification therapy. And so in terms of wanting to testify, what I see is some children will be advocates for testimony. They are strongly advocating to be given that opportunity. They're asking. I mean, I've had kids say to me during interviews, I wrote a letter to the judge. Now, I don't know if that letter gets there. I don't know how that works, but I wrote a letter to the judge. And then sometimes you see in parallel one parent also strongly advocating, I want my child to be heard by the judge. So it raises some red flags. So at the very least, it becomes part of an examination. What what underlies the motivation, such high motivation for testimony.
Who helped you? I always ask, oh, so who helped you write this letter? Did somebody suggest you write it? Did they write it with you? I ask those kinds of questions, general questions, open, and so they can kind of give me some guidance on who's influencing them to write that letter or doing that. But you're right. I mean, there are times definitely where parents are challenged in their own parenting ability, and that will come out. And sometimes they are very disinterested. We find a lot of absenteeism parents. I see, well, my dad's always on their phone, and so they never interact with me. Whereas my mom will play games, or vice versa, right? Not gender specific, but that's that parent needs to. They're not targeted in alienation. They need to improve their parenting skills. And also, I think, be aware of it. Sometimes when I interview kids and I'll say, this is what the kids told me. And one parent will be like, well, yeah, I tend to do that. And it's also educational, I think, at times for the parents if we do it right.
I think there's a lot to be gained if parents are open. I suppose it may not apply to the more extreme examples of parents that have a very rigid position and an expectation and a set of demands, such demands that they're often targeting everybody else for blame in terms of you're getting it wrong and you're not understanding and you must be biased or something like that. But aside from the more extreme examples of that, you see children sort of like in the middle, and you're wanting to liberate them, and you also want to be able to provide such information that parents end up benefiting. It's like from my standpoint as a therapist, it's not just creating findings and presenting findings to the court. There is benefit, I think, from a psychoeducational perspective.
Absolutely, I agree.
There's information. It's not the same as a parenting class, but parents can gain a lot of insight into their own children's functioning and into their parenting. And they may be unaware of the fact that they're influencing the children in a certain way or creating such guilt or polarized feelings. It's a lot of pressure on children to be in that state or in that situation. A lot of clinicians call it triangulation, putting the kids in the middle.
And I think, too, along those lines, that's so fascinating to me is that when I talk to kiddos, often they'll say to me, I don't care what the schedule is as long as my parents are okay with it. They don't fight. It reduces their conflict. If I can go whatever you want me to do and they're not going to fight anymore and I'm not going to be in the middle of it and I don't have to choose sides, then I'm okay with it. And I'm amazed at how often I hear that from kids. And when I ran the UNLV Cooperative Parenting Program, I remember distinctly I had this one kiddo. He was a teenager. And when he would go from mom's house to dad's house, he would go into dad's house, he would slam the door, and he wouldn't interact. And the dad said, I don't know what I'm doing. I don't understand. And the mom's like, it's because you're so difficult. And I said to mom, so tell me how you interact with dad. Oh, I don't talk to him. I hang up on him. I dismiss him. I'm not interacting. I go, wow, your kiddo's doing exactly what you do, right? Because your kiddo wants to be loyal to you, mom. Mm-hmm. Like, have you thought about how you're interacting? And I think, like you said, I don't think she realized that she was doing that. And I thought it was really informational for her. And we were in a classroom setting. I had over 1,500 people that went through that program. And sometimes just kind of talking about scenarios, they'd be like, oh, shoot, I do that. Mm-hmm. Or shoot. Or, you got the kid who's a cell phone, and they've got two different cell phones, a mom phone and a dad phone, or a parent one, parent two phone. And they won't, like mom won't let them take it to the other parent's house. And the other parent won't let them take the cell phone they pay for. And, you got these kids in the middle of these conflicts. And we need to know that as judges. Mm-hmm. So.
And often parents may be operating from a pretty genuine perspective where they think that they're being supportive to a child and that they're doing the best thing and they're advocating for them in such a way that they may not know creates tension in the child, not knowing, if they're supposed to take a side or favor one parent or express preference for one parent's parenting style and so on. And I think that the overall thing, I think what we're all involved in is trying to spare children in their development, these years of childhood where I've often said their childhood is hijacked sometimes from 100%. Such high conflict co-parenting situations, that we're trying to create a process where children are heard and respected and looked at as individuals not just as extensions of their parents, and that parents are integrating information that allows them to be children rather than to be advocates for a parent or represent a parent's point of view, or be polarized, take one side and try and marginalize the other parent. And I see a lot of that in my reunification practice.
And I think I would always see in the UNLV program, these parents would come in, and it was so interesting where they would say, so many of them that are in conflict, I don't want to hear about your mom's house. Don't talk to me about your dad's house. And if you're a kiddo on the playground at school and you're dealing with a high, difficult situation, you want to be able to go to the other parent and say, this is what's going on. What should I do? Give me guidance and advice. And if one parent won't allow you to mention the other parent's name or talk about their significant other, it's really hard for a kid to process that information on their own, regardless of the age, and especially really young kids. So tell me what you think are good parenting plan timeshares for parents based on age-appropriate parenting. I love that. I love perspectives on that, like for very young children, 0 to 3, and then maybe 5. And, because we are getting, and I talked to Emily about this before we started, we're getting some judges believe, well, the Supreme Court has told us we have to have a preference, so we're just going to go month on, month off. That's hard on kids. Would you agree with that? And what recommendations do you kind of think
I would certainly agree. Well, to begin with, that premise of month on, month off, I don't think that's appropriate for a child of any age, even 17 and a half, let's say.
I agree with that.
Well, I mean, think about it. They won't be seeing the other parent.
Well, they will in visitation, timeshare, the new Supreme Court case, in timeshares and parenting time. They'll see them, but one parent's primary, then the other parent's primary, then the other parent's primary. Or if they're long distance, they may not.
Well, that imposes another set of challenges, long distance. Proximity is a factor. But in cases where there is proximity, close proximity, I think developmentally that's a pretty good approach to look at stages of development or ages, child ages and stages of development. And the younger, so just to keep it very general here, the younger the child, I think that it is appropriate to have more frequent transitions, exchanges, not to have a young child, if you think about a toddler or a child up to 5, 6, even 7, spending a week away. I've observed this. I don't think children do that well, even with a week. It doesn't sound like a lot, but I think some of these formulations like 2, 2, 3, and then things like that are better for younger children. I think beyond a certain threshold, I think children then begin to adapt and can cope with alternating week schedules. Where I see parents struggle with that, even though developmentally their children are quite capable, and they can still have contact through FaceTime or telephone time or texting. Most people text these days, so even parents and children text. I think it's many parents that I see have a hard time being away from their child for 1 week. So it's a big transition for a parent to go from the more frequent exchanges to less frequency. And developmentally, I think then that children cope better with less frequency at a certain age. Certainly teenagers, very inconvenient for them, in a sense stressful for them to transition every few days back and forth. I've had, I remember a teenager in my office in a session with one of the parents, I'm not sure if both were in, say, you don't know what it's like. And the parent said, what is like? What it's like to act as if you're in a hotel and you're checking out and you're making sure that you get everything gathered up and go to the other hotel and check in and make yourself comfortable there. And then you keep doing this. The child said, you get to live in one place, even if you are divorced.
That's a really good analogy.
You get to live in one place.
Yeah.
I have to constantly go back and forth. So then I think, the point there is, so how often should they go back and forth? And I think you made an excellent point. Age makes a difference in terms of the capacity for a child to adapt to the frequency of transitions.
And the level of conflict too, because I see that I get teenagers who come in and they'll be on a 2-2-3 still, and the parents are in high conflict, and I'm like, why are you doing that? Like, let's talk about what would be better for you and for your kids, and like you said, emotionally making that change. But I do think it's hard at any age, right? It's hard, and it's hard for little kids to go back and forth and not have that primary attachment. But I also think they can do it if the parents aren't fighting incessantly. They're not fighting in exchanges, because these little kids, they pick up on those nonverbals that my mom doesn't like my dad, even if they're 3 or whatever. So I think it can be really hard. And I think the number one thing I used to say to parents is, it's not the divorce or separation that matters to the kids, it's the conflict, the level of parental conflict and how you deal with that. And really, if you are emotionally stunted, you're going to have a harder time yourself dealing with that. And I think even if you're emotionally mature, you don't want to give your kiddo up sometimes, right? I used to have to give parents permission at UNLV in the program. I'd say, it's your time away. You get to take a break. You get to read a book. You get to sleep in. You get to catch up on work. But what I would always caution parents about is, and I even now, don't take the perspective of, I have my kids this week, so I'm not going to work. Your kids need to see you working and doing normal things and cleaning the house and going to work. And if they only see playtime, they think that's normal. So you're modeling how to act and react in many instances and many perspectives.
And if you're only seeing your parent not function, almost shut down, that sends another kind of message.
Absolutely.
That child is responsible for the emotional well-being of that parent. And that's not a healthy dynamic to inspire or to support, maintain or promote in a child, that they are responsible. And I've had kids in my office tell me, I can't see my dad for so long this weekend unless my mom comes. I had a case like that not too long ago where they were expressing a lot of concern about their mom's functioning because mom's bored, mom's not doing anything, mom's just sitting at home waiting for us. And that's what the mom in this case was demonstrating as well.
Yeah.
She wasn't demonstrating that we're fine, everybody's fine, I'm fine, you're not responsible to, keep me entertained or keep me happy or whatever. But in this case, there was some synchronicity there. I mean, that's what the children were responding to, that the mom had that very heightened need for them to be around all the time.
Well, and I think we see that a lot. Like if you say, I'm going to miss you so much, I'm so sad. I got to tell you the story. I did the opposite because I was in a custodial situation, a long distance one. And when my kids would go, knowing that research, I would say, you guys are going to have so much fun. I'm so excited for you to go. You'll have a great time. I'll be fine. I've got to work. I'm going to do this and do that. And then one time my older son said, Mom, you like us to go. I was like, no. I'm glad you're going. You have time. When my youngest daughter was about 5, she was doing an exchange and she didn't want to go. And she said, no, I don't want to go. I want to stay with you, Mommy. And it's not that she doesn't love her dad. She did. And so I said, well, you could stay with me and I'm going to clean all the toilets and I'm going to do all of the chores while you're gone. And Daddy's going to go camping and they're going to go kayaking. And she's like, okay, I'm going with Dad. But that was my responsibility, right, to take it off of her and give her those options. But I did go overboard, so I had to self-correct because I didn't realize I was like almost saying like, yeah, go. So it is kind of that balance. But I see exactly what you see, the parents just almost breaking down, some parents, when their kids go.
I find, I try to tell clients sometimes there's a big difference when you're sending your kid to the other parent where you say, oh, it's going to be okay, it's going to be great, or it's going to be okay, right?
Right,
Like
100%.
There's a huge difference in those two things and how that kid's going to respond to going, when you just put your fear
100%.
or your emotion onto, your apprehension onto the kids.
I had this one case where this mom was testifying, and I said to her, what do you tell the kids when it's time to go to Dad's? Well, I tell them they have to go or I have to go to jail. And I'm like, okay, so that's, putting something on your kids right there.
Yeah. And sometimes one of the questions that gets raised, one of the points that I think you raised is about the psychological and emotional health of the parent, which is, I think, something that custody evaluators certainly hone in on as well as part of their very extensive study. What is going on in the the psychological functioning, the world of that parent that they can't seem to convey and support a healthy boundary, that it's okay.
Now you don't do child custody evaluations, but you do some very specific types of evaluations, such as like an alienation assessment, and brief focused evaluations, I think, which are more finite custody evaluations. Is that true?
Yeah, I think the major difference that can be described, the difference between a custody evaluation and a brief focused assessment. I mean, some of that is understood through the very term, brief and focused. It's an assessment. A custody evaluation is a very extensive study, and some people that I know, and I've done some in the past, and as well as relocation risk assessments, which I did more of in the past. But custody evaluators, they spend many, many hours. It is an expensive process too for the participants, examining everything, every facet of history, of a parent's history. Some of them are psychologists, so they'll do psychological testing as well. So that's where I say they hone in on the psychological functioning of a parent and maybe what that need is, not to create a healthy boundary. In a brief focused assessment, it may contribute, but it may not be about helping a judge determine what custody should be or how custody should be formulated. It may be an answer to certain questions. So in a brief focused assessment, it's fairly broad. It's much broader than forensic child interviews because you're including parents and you're looking at certain areas, but some of those areas are specified. They're outlined in the order. What things to investigate. Could be more about the children's academic functioning or what's going on in terms of support for school or the children's parenting, the parenting for the children in certain areas. Could answer certain questions like, are there abusive behaviors going on? Are there alienating behaviors going on? I can think of many examples, but it is more streamlined, it is more focused, it sometimes answers specific questions that are provided as far as what the focus should be. Much different than a custody evaluation, which examines just about everything. And every one, they include collateral interviews, interviewing other people and institutions and schools and teachers and whatever in the child's world, let's say. What's even more specific then, I think what you mentioned is, and it may not be considered a brief focused assessment, but an alienation study. So the question that's posed then to the clinician is, for example, I have a case right now, 2 questions are the most fundamental for the judge. There are allegations of abuse. Well, the CPS hadn't done anything. In fact, there were no reports, no investigations by the CPS. But the question is there abuse going on? What's considered abuse? Is there abuse going on? And then the other question is alienation. Is there a component to this child's functioning in which they have certain views and preferences about one parent that is underscored by alienation? And sometimes people don't know, is this just really the child's preferences and there's a basis for it? There's a rational and justifiable basis for what I often see as, and I label, I suppose, as resistance, avoidance resistance as a dynamic in a child that is not wanting to spend time with one parent. And depending on the presentation, and a lot of things have already been looked at in court, the judge may say, let's take a look at this question. If it's not justifiable, is the child influenced in such a way that there are alienating parenting behaviors occurring that affect the child's attachment or have disrupted the attachment between the parent, this parent, and the child?
And I think brief focus assessments are really good for that. And I always like to say that kids have a voice but not a choice. And that's important because their voice is so important. But I don't want to put it on them who they're going to live with. It's not their fault, so to speak, that one parent may have a different timeshare. And they need to know that they don't carry that burden, right? That's my burden to carry. And I'm going to make those decisions. And so often I see judges send things for interviews that say, well, which house does a kid want to live? that's not really an appropriate question, right? Like, tell me about your mom's house. Tell me about your dad's house. What are things you like? And I often, conclude with, if I could give you 3 wishes, what would those wishes be? Because inevitably, if there's conflict, one of those 3 wishes, instead of going to Disneyland, is going to be spending time on, can you help my mom and dad, or my mom's or my dad's get along, right?
Yeah.
And that's sad. Because like you said, we're taking away their childhood.
That is one of the wishes that children will express a lot of, from my experience. They want their parents to get along. Whether you're acting as a parenting coordinator or in a therapeutic role, many times the call is to help parents become more cohesive and to help parents understand the importance of that and the value of that. Such tremendous value for children to grow up in the context, even if they have dual households and their parents are separated or divorced, that there is some semblance of cohesion, cooperation.
Yeah. Do you think a lot of that is based on the parents' emotional functioning too, though? Like, I think that if the parents are more able to set boundaries, deal with their own stressors, they're able to usually co-parent better than the parent who refuses to let the other parent to engage, refuses to say anything positive about the other parent. I mean, I remember I used to have to say to my kids, like, well, I like mustard on my hot dogs just like your dad. I mean, sometimes it starts with a little thing, right? Like, but they hear one positive thing and they're like, okay, I don't have to compete in this household. UC Davis did it years ago. I think it was 2003 even, but they did this study, these 2 professors, on how we in custody courts are teaching parents to be poor parents because we're competing. Who's going to get them the bigger Christmas present? Who's going to get them, give more TV time or gaming time? We actually kind of had a joke in our household that when my kids would come home from their dad's house, I would inevitably say, your dad's a much better present giver than we are. And we laughed about it because he is. He's a fantastic present giver. And he takes these kids on these amazing adventures. And I can't compete, because I'm getting them underwear and jeans and, a helmet for their football team. But that we kind of joke about that. Like, your dad one-ups me on that because he doesn't mean to, but he is awesome at it. And I'm not. So I kind of joke about it, right? Like, it's not intentional. But there are times, I think, that kids tend to think that parents are competing. But there are actual competitions. If you have a custody interview, a custodial interview, I actually say, well, what are you going to do after this? And who's going to take you? And what did you do last night? And what did you do this morning? And it's crazy where these kids will go, my mom bought me a new bike last night, or my dad bought me a new gaming system. And you're like, okay, but that's important, right? That you got to ask that question. But a lot of interviews don't ask those questions. And that's when I worry. So that's why I like forensics interviews as opposed to just a real quick cursory one. But I have fun with it.
I like your comment about sort of a suggestion that maybe the whole premise of presenting motions and conflicts in family court can contribute to the contest, where it becomes a competition and let's see who scores higher or better and so on, and sort of driving parents to make those presentations, right, in competition with the other parent, as opposed to, and there was an attorney that I knew many years ago who said, well, Nick, the courts are supposed to be conciliatory courts. And I said, well, I didn't see that posted on top of it.
No, we should, though. We should have it posted. And I know we had one case years ago where this kiddo told dad, oh, mom drives drunk all the time. Like, the kiddo said that, right? And so then you get into an interview and it turns out they're both drinking and driving, right? And then it's like the kiddo told dad one thing and then they tell the interviewer something else. And then, one parent gets mad. And I always say to kids, I'm going to tell your parents they're not allowed to have a conversation with you about this interview. Because otherwise, in that case, the dad went to the kid in the dentist chair the next day, you told the judge. And I'm like, no. Because their attorney was present, didn't tell the parent, you can't discuss this with the kids. Because the kids bear so much guilt sometimes over telling the truth, and we don't want them to.
We can't guarantee that. We can't enforce that. I think that's the generally healthy orientation, to make sure that parents, if I understand you correctly, don't talk to their kids about what
I can
goes
order
on.
it, but right.
I have a feeling sometimes that I'll interview a child and then a parent almost immediately on their way to the car in the parking lot are debriefing them and wanting to find out what occurred, what did you say, why did you say that? Why would you throw me under the bus? And that kind of thing, right?
100%.
So I think you're speaking to, again, the psychological and emotional health of that parent who may be more invested in winning, and I hate to use that term. The other thing is that I believe you suggested is that there is a lot of resentment that drives conflict and dispute between parents, where then custody is the question of who should have more or who should have it all or whatever. I've seen presentations where people want sole custody. That's it.
All the time. The time.
So is it that there are legitimate concerns about the parent, and if there are, can they not be rehabilitated and so on? Or is it that a parent has such immense resentment? I can answer the question in the affirmative. Yes, I see it. There's such immense resentment sometimes that is the driving factor, not necessarily a protective factor versus risk in the other parent. It's they just can't stand them.
And I think it's interesting when one parent moves on into a new relationship that they get a lot of anger built up oftentimes. And the other thing is that I think a lot of parents can't answer the question, what was your role in the breakdown of the relationship, right? Because if we can individually take responsibility, like I could have done that. And again, I'm not saying that that happens in every case, because certainly there's cases where there's deep-seated addiction and there's not necessarily fault to blame. But I think, for example, I'll give you my own situation. I say to my kids, I think I was critical of your dad, and I wish I had been different in my marriage to your dad. I need to take responsibility, and this is why. Because if my kids don't see me taking responsibility, they're learning to grow up blaming everybody else for their circumstances. And I think that's really important for kids to know, especially adult children. And my kids will say, I really appreciate that you and dad, can get along and you're not fighting, and, you don't have to worry about that. And it's stressful for kids, even as adults, right? Because you got marriages and grandkids and, things like that. The kids don't want to have to focus on that, and they get mad if the parents are making it about them and not the kids' event.
One of the biggest things I think I've learned as a parent from being a family law attorney is to not let my kids feel any conflict or feel any negativity, or to shield them from anything that might be going on, and make sure that they just have positive feelings and get to live their lives as children the way children should be, unencumbered by responsibility for their parents' emotions or for the conflict of their parents.
They really have a right to be to be kids, right? Our kids have a right to be a kiddo, not have to be managing, like you've talked about, the parents' expectations, like, oh, mom's going to be sad while I'm away, or dad's going to be mad while I'm away, or whatever it might be. And I think of the many times where I've had situations where one parent will angrily drive their kid, the kid up for an exchange, and there'll be words spoken that are terrible, and the kid observes or sees. I remember, I've got to tell you, one time I had a case where I did the custodial exchange, and the dad said, I didn't say anything to her, so my exchange was fine. And I go, well, when you flipped her off, when you turned around, your kid senses that. And he was like, I don't see how. And he just couldn't understand that not speaking is speaking, right? So a lot of those things that the parents have a hard time sometimes understanding.
Sometimes when I'm educating, or at least try and educate parents, I'm suggesting it's not so much what you don't do. You say you didn't do this, I didn't do that. But what you can do, what you do demonstrate to your children, like, of course, there's some resentment pointed at me sometimes for even making such a mere suggestion of, why don't you say hello?
Yeah, right. That's the biggest thing.
Say hello to the co-parent.
Right. That's emotional resilience. That's emotional maturity. You acknowledge somebody. I agree.
So I have in the building where my practice is located, there are 2 waiting areas on different levels, and often parents take their seat in these 2 different areas. They won't sit next to each other. Yeah. I'll see a parent try to do something that I suggested, and they say, hello, how you doing today, to the co-parent, and the other parent lowers their head and ignores the whole gesture. And I then remind them, okay, well, that's what your children are seeing. And I think a relevant question, for what it's worth, is what kind of childhood do you want for your children? Given that they didn't ask for any of this.
It's a good question.
And I think it's okay. You shouldn't be a wooden kind of clinician. Like, it's okay to show empathy. You really should show empathy for the children, particularly. Like, you feel for them. You want them to have, they're not your kids, but you want them to have a stable and healthy childhood and have memories of things that were pleasurable and joyful and good for them, rather than memories of nothing but conflict. And so, asking parents to step up and be a little better in their conduct towards each other, I think, is supportive of children and demonstrating empathy for children as well. This is a predicament that has fallen upon them.
Right. I always find it interesting, like a soccer game on Saturday or our orchestra concert at school, and the parents are on two sides of the stadium, and the kiddo has to choose after the event, who am I going to go talk to first?
Oh, that's a common one.
And they're very common. And I always ask the parents, can you be mature enough to sit together? Just start with that. That's huge, right? Like, a lot of parents are like, no way, especially if they have significant others. But that's, for a kid, that's a really hard, who do I look to?
And I'm sure you've seen different answers to that.
Yeah.
If you ask it,
yeah.
Can you?
Yeah.
Well, some of my clients will say, no,
Nope,
I can't, and I won't.
I won't. They refuse to do it.
Right.
And like a parent-teacher conference. So I actually have a provision in a lot of my orders that say that you can only go to a school event on your timeshare, depending on the level of conflict, unless it's otherwise agreed by the parties in writing. And that's because those kids get so caught up in their managing their parent stress at the most important times of their lives, graduations, concerts, the things that we hopefully look back on and say, remember when I was in 5th grade and I sang at my concert and I wore my fancy dress? A lot of our kids are more stressed about their parents' reactions.
And sometimes you're creating that boundary. Mm-hmm. I think that a court order, a judge will sometimes be compelled. It could be a recommendation from me, but it could be translated then into an order where it is better not to have the parents interact or be separated. Certain events and activities, they can go on their time. Mm-hmm. Because if there's a pattern, a demonstrable pattern where the parents continue to engage in conflict so overtly that children are distressed, significantly distressed, then you have to keep them apart. You have to set the boundary.
And it's so interesting, like, you'll have a Saturday soccer game and maybe dad's the custodial parent at that time, and mom or dad too will show up, and then they'll try to lure the kiddo away. Let's go for some ice cream. Let's go, it's not even their timeshare, and they'll try to lure that kiddo away, or come to my van and have a snack, or I've got better snacks. It's so stressful for the kids. And I tell parents, when I worked in juvenile justice and parents would walk into the courtroom with intense hate for each other, I would say, you're surprised your child's in drug court. They're trying to manage you. They're trying to manage the emotions that you've created. So
it's unfortunate.
A lot of these kids are going to have personality disorders or mental health or substance abuse issues. So what do we want for our kids is a great question, I think. Yeah. So.
Well, thank you guys for coming and talking about this wonderful topic today. I think we all learned quite a lot.
Well, thank you for the opportunity.
Yeah. It's fun. I enjoy what I do. I really do.
I can tell.
I'm very passionate about it.
And I think that you're exposed to every dynamic that I'm exposed to from the sounds of it. Yeah.
Absolutely.
You in the legal forum, let's say, and me in a clinical forum, but we're both engaged, I think, in trying to create the same outcomes. Better outcomes.
Well, and I think too, like when you come to a case management conference, it's amazing how often you can get the parents to resolve when you say, well, here's your motion, here's your opposition, here's the law. Yeah. Here's what I can do and what I can't do. And they're like, oh, okay. And it's kind of interesting. So I believe, it's the legal responsibility of all attorneys to manage the expectations, to help the clients get to a place where they come to court and are ready and willing to listen to what the judges are doing and why we're doing it. But I think it's important to engage the kids in some respect.
Yeah. Well, thank you.
Thank you. It's been fun.
And thank you, Emily, for the opportunity.
All right. Thanks, Emily, for inviting us.